Today, UCMC Center for Reforms will be discussing the situation with providing free legal aid in Ukraine. That is the project that started in the beginning of July. We were talking about the plans in the center, and today this is the first report for the first 3 months of work. That's the project that Ukraine is to implement as the member of the Council of Europe. I would like to invite Mr. Andriy Vyshnevskiy, who is the director at the Legal Aid Coordination Center. Good afternoon, esteemed colleagues. 2.5 months passed since here we were talking about launching the next stage of the state program of providing free legal aid. We were then talking about our plans and intentions, about how much we're ready to start this next stage. We do have some preliminary results and interesting data that we would like to share with you. Basically, I will start from reminding you that the free legal aid started in Ukraine on the 1st of January 2013, and since then it has been provided only in criminal cases till the 1st of July 2015 to people who, because of their material status, were not able to hire the lawyer, or in cases if the person did not hire the lawyer independently. I would not be talking about all the details. There's a lot of information in open sources about that, but I would like to draw your attention to some figures. In the end of 2014, we paid attention to a big number of the justifying sentences in cases when the lawyers were appointed. That was 33% of all the sentences. What is the justifying sentence? That means that the person who was accused in committing the crime was recognized by the court to be innocent. When we analyzed the data of the first half a year of this year, we saw that the percentage of those criminal cases where lawyers managed to get the justifying sentence increased, and the correlation. So today, 64%, almost 2/3 of all the justifying sentences are sentences in criminal cases where the free legal aid was provided. That certifies to the enhanced quality of the legal aid, and it talks about enhancing the efficiency of the systems of providing legal secondary aid. I will give you 2 examples. In Cherkasy, there was a case when the person was accused in the murder. The sentence had to be 15 years of imprisonment. The person was stayed 6 years in detention while the investigation was going on. In 2013, the Cherkasy Center of Free Legal Aid was given, the person was given the lawyer, and the person was recognized non-guilty, and the person after that got married and lives happily in marriage and has a child. So you can see how the free legal aid helped a person who did not commit a crime. Another similar example is in Lviv region. The person who had some psychic disorders was accused in committing the murder. It's classical situation when the minors or persons with psychological disorders are accused in the crimes that such people did not commit. And that improves the statistics for the law enforcement bodies, but our system helps combating these practices. Also, the person was recognized as non-guilty, and that sentence was also confirmed by the Court of Appeal. Now let's talk about the new 100 centers for legal aid. As of now, within 3 months, almost 16,000 citizens came to such centers. If we look at the services provided to citizens, we will see that almost 70% of those who requested aid, the consultations are given, and these consultations help the person to understand what is the problem about and how the problem could be addressed. In 31 cases, after such a preliminary consultation, the person writes the request to the center to requesting for the free legal aid. That means that the person has to go to the court and defend their rights in the court. And in 20% of all cases, when people came to the center, the lawyer is provided to present the interests in the court. These are cases when the person meets the criteria of the person having low income, and then such legal aid is provided. As to this, which were the issues, first of all, that social maintenance, the recalculation of pension and other pension issues. The second one is the issues related to housing, to getting subsidies, then the heritage law, family law, and labor disputes. If we talk about the structure of the clients who come to the center, more than 43% are disabled. Almost 39%, these are the people whose income is less than subsistence level, despite the fact that the system has been in place for less than 3 months, and we are providing legal aid in 3,000 cases. There are some cases which were finished, like in Kiev, the lawyer Bogdan Moisenko helped the client to win the case on recognizing the heritage, the testament void, but the people basically changed the amended the documents, the will, and this will was eventually recognized as void. Then the disabled person came, whose son was killed in an anti-terrorist operation, but it was impossible to recognize him as a person who was killed in an anti-terrorist operation. The lawyer was appointed, and the lawyer, with the assistance of all the evidence that were provided by the father, the court basically stated that the person really was killed in ATO. That was the precedent, the first precedent that took place in Kharkiv region, and such thing could help people who were wounded, and could help the families of those who were killed, and they will be getting the compensation that they are eligible to get. We have almost finished preparing the facilities. We provided almost all the equipment to all these 100 centers. The centers are created for people. The person who comes to get legal aid should feel comfortable there. These centers have very modern copying, scanning equipment and other types of equipment, so that the person who comes with documents does not have to go and copy the document somewhere. All that is done in the center. Also in the center there's a room for the work of lawyers. Also there are one or two desks with computers, with all the internet communication, with the access to all electronic database, and the lawyers can use it as a temporary working zone, similar to co-working, where they can go anytime. There are cases in order to submit the appeal, people have to copy thousands of pages, and that is done by the lawyers in the centers, and that is why we bought all this equipment, for which the line was planned in the state budget. In the process of providing free legal aid during the first 3 months, we saw certain injustice in this defining the criteria for those people who should have the right for free legal aid. The law was passed in 2012, and it doesn't take into account all the events that took place in Ukraine after that, in the result of which we got new categories of vulnerable people who require legal aid. First of all, this is about the criteria of low income, because today we have the right to provide the lawyer only to a person whose income is lower than the subsistence level, but we don't know that we do not have a pension which would be lower than subsistence level. There is a rule, several hryvnias higher than subsistence level, and we need to convince the pensioner that the pension of 950 hryvnias is a big pension, and the state cannot provide free legal aid. The same is true about the participants of the military actions, but the law on free legal aid sets the limits that we can help them, such people, in addressing only social issues, but they come with other problems, like the issue about getting the land plot or related to housing. The same is true about those persons who are participants of the military actions, but they have problems with getting the status, and also IDPs are not the subjects of this law. We have analyzed all these problems, and we drafted the law, which was supported by the Cabinet of Ministers of Ukraine. It has the registration number 3044. It's now in the Verkhovna Rada. It will allow to address all these issues and to specify the criteria, because in fact, according to our assessment, about 25% of people who do require free legal aid and who cannot hire the lawyer, they cannot get the free legal aid. These are many people. In fact, we've heard from open sources the proposals and statements of the leaders of the National Association of Disabled, that the association is ready to organize free legal aid to everyone who has right to get it, and the National Association doesn't require any additional funding from the budget. While the draft law 3044 is adopted, we do hope that the Parliament will support it. The time will it will take some time because it hasn't been included into the agenda of the Verkhovna Rada. Then there's the procedure, the first reading, the second reading, and then the President should sign it. And we understand that several months will pass, and the Ministry of Justice sent a letter to the National Association of Lawyers with request to introduce amendments to the letter, to the document. The Ministry of Justice suggests to introduce amendments to the memorandum, which would allow the National Association to really execute what they are talking about, and we hope that in the future we will have very fruitful cooperation with the Bar Association, and we will help our citizens to get free legal aid. Thank you for attention. I'm ready to answer the questions.
Сказали про один випадок, коли доведено справу до суда.
Could you please tell in more detail about the statistics on the results of the center activities since July? We have no data by now. We have the data that 3,000 court proceedings are now on the way, and the lawyers have been assigned from our centers to the defendants. And now about all the win cases, we inform the general public, and at our website you can see several cases as an examples, and I told you about the two of them today. And what about the matters of subsidies? You said they are second in the list of priorities. And the system of granting subsidies is imperfect, and it should be modified. And what about the reform? The government is saying that the reform with subsidies is a success. I have no grounds to tell that all the system of granting subsidies is inefficient. This is we are speaking here about individual cases on ad hoc basis. In most cases, we just help people to fill the application forms and to collect the required documents so that they can get such subsidies. And our lawyers help people to collect such documents. Oksana Korzechivska, in our materials we have the information about the briefing of Громадский контроль. Could you just give some explanations about the use of budget allocations? There were some allegations, and how will you comment the statement of National Association that your center tries to make more government like this assistance. What is this comment of these allegations? I just asked to comment on the information in the media. And the second question is that many times the center provides free of charge the assistance. Could you comment your attitude to the allegations? First, I would like to say that the public control is good always, and each organization which uses budget funds, it should be accountable, and we have been transparent from the very first day of our activities, and all the information is available at our website along with the audit statements. This fact is the main reason why the National Association of Lawyers of Ukraine may tell something and do some and reach some conclusions. I wouldn't like to comment the information which was told on a briefing on September 14. It was 11 pages, and we disseminated the materials among the journalists, and I would say that there were no figure which the National Association of Lawyers, there is no figure which would be true. After the briefing, we will post all the materials at our website after this briefing. As concern the risks that the bar could become some government-bound one, then the free of charge legal aid has been recognized internationally as the most liberal one, because the fundamental principle is a voluntary basis of lawyers' participation in this system. Lawyer takes his own decision whether he would like to work on voluntary basis, and we conclude contracts with the lawyers where a client is a government which represent individuals. And this is stipulated in Part 27 of the law, in Part 4 of the law 27. And the lawyer decides on the scopes in which this lawyer is going to provide services, for example, on daytime or maybe in the night time, and whether this lawyer is agreed to go to some field visits. So speaking of this model, we can't speak, there are no grounds to talk about any government control. The government doesn't control any lawyer. There are no mechanisms for the government to control. The government is just a client. And the government also provides very small amounts of remuneration for lawyers, but they also offer some methodological recommendations which are printed and free of charge disseminated among lawyers and the opportunities to share experience and lessons learned and to elaborate some strategies of defense. So the answer to the question whether the government press on the lawyers, the response is that many lawyers go to the tenders and there are very many applications for the tenders. Now we hold the 8th tender and the lawyers are interested and they are ready to work within the system of free secondary legal aid. So I saw no sense in the messages and in the allegations that the center provides some government control over the lawyers. So we can now speak about those who divide the lawyers who provide free of charge services and those who provide only paid services. This is just a dirty technology which has the aim just to blame the lawyers. In our opinion, the system of free secondary legal aid became the target for the attacks from some conservative and corrupt justice system. There is a lot of data and sociological research that every week some lawyer is detained and alleged and accused of some corrupt actions. When a lawyer for a very small amount of money which the government can pay and he put all the efforts in his in the legal proceedings where a person may even win the case or the limited accusations are accepted. So the lawyers compete. It stirs the competition between the lawyers, makes them more proactive, minimize possibilities for some illegal agreements with investigators, and there is some part of lawyers who dislike this. We have the time only for a very small question and very short answer. The Institute of the State and the Law, whether the center conducts some activities with people who are detained and when people are in detention and no lawyer is called for. Do you conduct any activities? Yes, we have 3 areas in this kind of activities. The heads of the centers regularly conduct trainings for law enforcement bodies where law enforcement bodies members are instructed and trained that all detainees have the right for a lawyer, and also we issue banners where we say that persons have the right not to give any witnesses or any information without a lawyer, and that they should not accept the lawyers offered by law enforcement bodies. And so this says for in favor of that the investigators intentionally violates the rights of the accused. So under the results of 2014, 18 investigators have been made accountable upon our letters which we submitted. And now we are expecting in several minutes the next briefing. Colonel Alexander Martuzanik will say about ATO related issues. So we invite you to come again here. This is an important information. We will see you